There's a hidden danger lurking in thousands of Georgia deeds right now. Let's talk about that. If you don't catch this danger on your deed before you die, it could cost your family tens of thousands of dollars and months of unnecessary stress. Now, I'm specifically talking about married couples here because this mistake is so common and it's so easy to fix if you know what to look for. There's a really good chance your deed has this exact issue, and when you pass away, your spouse is going to be forced to go into the probate court, even though you thought you had everything set up correctly. But here's the thing. Most people don't have any idea that this is a problem, that it even exists until it's too late. Before 1994, Georgia did not automatically recognize joint tenancy with rights of survivorship unless the deed explicitly stated it, the survivorship intent. If it was silent, it was treated as tenants in common. In 1994, Georgia updated and clarified the process and enforceability of joint tenants with rights of survivorship through legislation. This law made it more straightforward to establish joint tenancy with rights of survivorship by including specific survivorship languages in deeds and titles. But guys, I even see this today. Well, after 1994, where closing attorneys will just put tenants in common on the deed. This happened to a couple who wasn't married, mind you, but they were both buying the house together. Had I not brought up that they were going to be put in tenants in common on the deed, and if they had no will, because most likely they didn't, then if one of them were to pass away without children, all of a sudden the other one would own a house with their loved one's family, depending on who was standing next in line to inherit. Even if you are married without a will and you have tenants in common and your spouse dies and you have children, you now own a house with your children, which sometimes you might not want that to happen. Lord help you if you have minors, because not only would you have to go through the probate court, but the court would assign a guardian over the children to oversee the sale of the portion of their house. As you can see, it can get in a hot mess in a real quick minute. So in this video, I'm going to show you exactly what this hidden danger is and how to check your deed, whether or not it has it, and most importantly, how to fix it before it becomes a nightmare for your family. All right, let's get started. What most married couples believe about their home. You and your spouse bought a house together. Both of your names are on the deed. So naturally, you assume that if one of you passes away, the house automatically goes to the surviving spouse. Makes sense, right? You're married. You own it together. It should be automatic. Instead, your half goes into probate court. And that means your grieving spouse now has to hire an attorney and go through court, waiting months, over sometimes a year, and spending thousands of dollars just to get what they thought they already owned. Hopefully you have a will that says your spouse gets the house when you pass away and they don't have to go through the scenario I mentioned above. So what are these magic words? Joint tenancy with rights of survivorship. If your deed says joint tenants with rights of survivorship, then you're good. Your spouse will automatically inherit your half of the property when you pass away. No court, no probate, no drama. But this is where the hidden danger comes in. And if your deed just says tenants in common without those magic words, the rights of survivorship part, then that means probate is required, even if you have a will. Now, you might be wondering, why would my deed not have this? We bought the house together. Didn't our attorney handle this? Here's the thing. Rights of survivorship language is actually a relatively new concept to Georgia and its real estate law. If you bought your house in the 60s, 70s, 80s, heck, I've even seen it in the mid-2000s right up today. There's a really good chance that the language wasn't included on your deed. It was just a standard practice back then, and I'm not throwing any closing attorneys here under the bus. I still see it happen today sometimes. Therefore, thousands of Georgia homeowners, especially those older couples who have lived in their house for decades, have this hidden danger sitting on their deed right now, and they have no idea. But here's the good news. This is one of the easiest estate planning fixes you can make, and it doesn't cost a fortune. All right, so here's what you need to do. Step 1, find your deed. If you don't have a copy, you can usually go to your county clerk's office or online through your county property tax records and find your information. Step 2, look to see how you and your spouse are listed as owners. Does it say joint tenancy with rights of survivorship? If yes, you're good. You can breathe. Easy. But if it just says joint tenants, or tenants in common, or even if it just has both of your names and no other language, you've got a problem. Step 3, fix it. Now, fixing this is actually pretty simple. You just need to work with a Georgia real estate attorney to create what's called a corrective deed. Basically, you're going to redeed the property to yourselves, but this time with the correct language, with the rights of survivorship. This usually costs a few $100s. And that's it. And therefore, for a very small investment, now you can save your spouse from months of probate court and thousands of dollars of legal fees later. And honestly, this is one of those things you don't want to put off, because here's the reality. None of us know when it's going to be our time to go. And the last thing you want in the world is for your spouse to be grieving for your loss and then get hit with, oh, by the way, you have to go to probate court. Don't let that happen to your family. Now, here's what a lot of people don't realize about fixing this one piece of the puzzle. If you really want to protect your family and avoid probate altogether, you need to think bigger. Most people don't even know where to start. They don't know what questions to ask. They don't know what documents they need or what mistakes to avoid. So reaching out to a really good real estate planning attorney, maybe even an elder care attorney, would be the good first step in making sure at the very least you have a will, and discuss other options, maybe even explore trusts, because trusts are private and probate isn't. And look, I get it. Estate planning isn't fun. It is not something you want to think about. But it is the one most loving things you can do for your family, because when you're gone, they're going to have enough to deal with. Don't leave them with a legal mess on top of all their grief. So do yourself and your family a favor. Check your deed. Make sure your legacy is protected. And hey, if this video opened up your eyes to something you didn't know before, do me a favor and subscribe to the channel, hit the bell notification. I drop new videos every week on probate, real estate planning, and family legacy here in Georgia, because I am a real estate agent who specializes in probate and helping make sure that people protect and transfer their wealth through real estate. I'll see y'all later. Bye.